Plaintiff's rudeness here does not appear to be a momentary lapse. Dave's other video submissions to this court show that after his release he continued to repeatedly swear at, insult, the spipped officers present, even going so far as to belittle one of the officers for being old. See Dave's live feed video showing Dave calling a gray-haired officer Old Man River and telling him to F*** and hashtag off old man. ROA 22 to 40,653.257. Plaintiff's rudeness does not alleviate appellant of all rights and constitutional protections. There is no law that mandates that the people, the wellspring from which government authority flows, must at all times be polite to the government agents. However, there are laws that prevent the government from retaliating because the people were rude. Hence the label law enforcement and not feelings enforcement. This nation was created based on the assertion that government was to be limited and untrusted. The First Amendment protects the people's God-given right to openly criticize our government verbally and through press, and these rights are absolute, not abrogated based on rudeness. Over 40 years ago, the Supreme Court for the United States famously stated, freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. Houston v. Hill, 482 U.S. 451, 462-63, 1987, emphasis added. 40 years in Texas still has not realized that free speech cannot be used as a reason for the police to attack. Since Houston, every court that has considered the issue has held that criticism of the police, no matter how offensive or vulgar, is First Amendment protected speech. CEG United States v. McKinney, 9F Apex 887, 889-90, 10th Circle 2001, Buffkins v. City of Omaha, Douglas CNTY, Nebraska, 922F.2D 465, 472, 8th Circle 1990, Brant, 300F, Sup. 3D at 1281-82, Stone v. Juarez, No. CIV 05-508JB/RLP, 2006, USDIST Lexus 27272, at *34, DNM April 23, 2006, Clary v. City of Cape Girardeau, 165F, Sup. 3D 808, 813, EDMO 2016, Cavazos v. State, 455N.E.2D 618, IND 1983, People v. Gindello, 324N.Y.S.2D 122, 124-25, New York CRIMCT 1971. Moreover, every court that has considered the use of the word fuck in the modern era of First Amendment jurisprudence, whether directed at an officer or not, has held that it is speech protected by the First Amendment. Cohen, 403 U.S. at 21, Lewis v. City of New Orleans, 408 U.S. 913, 1972, Brown v. Oklahoma, 408 U.S. 914, 1972, Rosenfeld v. New Jersey, 408 U.S. 901, 1972, United States v. McDermott, 971 F. Sup. 939, 942, ed. Pon 1997. In light of the above, it is staggering that the magistrate for the Southern District of Texas Brownsville Division either has not attained a sufficient competence in law and at law to be aware that rudeness does not create probable cause and being rude to police does not grant the police immunity from suit for malicious violations of constitutional law, or chose to ignore such and deprive appellant of such protections. Appellant was speaking at a traditional public forum for speech. Appellant's speech occurred at a traditional public forum, a virtually empty public parking lot adjacent to a police station. Public places historically associated with the free exercise of expressive activities, such as streets, sidewalks, and parks, are considered, without more, to be public forums. United States v. Grace, 461 U.S. 171, 177, 1983. Such space occupies a special position in terms of First Amendment protection, and the Supreme Court has repeatedly referred to public streets as the archetype of traditional public forum. Snyder v. Phelps, 562 U.S. 443, 456, 2011, quoting Frisbee v. Schultz, 487 U.S. 474, 480, 1988. Chaplain Sky is a dead letter and, therefore, the disorderly conduct statute facially violates the First Amendment. TX Code Section 42.01, 1, tracks the language used by the Supreme Court in Chaplain Sky v. New Hampshire, where the Supreme Court created the fighting words doctrine. 315 U.S. 568, 572, 1942. Yet, the Supreme Court has overturned every single fighting words or rudeness conviction it has reviewed since Chaplain Sky was decided in 1942. The defendant in Chaplain Sky was arrested and convicted for saying to a police officer that he and the whole government of Rochester were damn racketeers, and fascists or agents of fascists. Chaplain Sky, 315 U.S. at 574. The law that the defendant therein was arrested under made it a crime to address any offensive, derisive, or annoying word to any other person who is lawfully in any street. ID at 569, quoting CH 378, 2, of the Public Laws of New Hampshire. The Supreme Court affirmed that conviction. However, since Chaplinsky, the Supreme Court has repeatedly held that language that is, on its face, more likely to incite an objectively reasonable person to an immediate breach of the peace than the language used by the defendant in Chaplinsky is protected by the First Amendment and cannot be criminalized. See, example, Termine Yellow v. Chicago, 337 U.S. 1, 4, 1949, holding that calling a religious minority slimy scum, snakes, and bedbugs is protected speech. Coons v. New York, 340 U.S. 290, 1951, holding that calling Catholicism a religion of the devil, the Pope the Antichrist, and Jews Christ killers and garbage that should have been burnt in the incinerators of Nazi Germany is protected speech. Gregory v. Chicago, 394 U.S. 111, 1969, reversing convictions of protesters for disorderly conduct that called the mayor a snake several times over. Gooding v. Wilson, 405 U.S. 518, 535, 1972, affirming an appellate court's vacating a conviction for using opprobrious and abusive words on First Amendment grounds of a defendant who told a police officer, "White son of a bitch, I'll kill you," and "You son of a bitch, I'll choke you to death." Rosenfeld v. New Jersey, 408 U.S. 901, 1972, reversing conviction of an individual who used the adjective motherfucking on 4 occasions to describe the teachers, the school board, the town, and his own country. Brown, 408 U.S. at 914, reversing conviction of defendant who called police officers that black motherfucking pig and motherfucking fascist pig cops. Papish v. Board of Curators of the University of Missouri, 410 U.S. 667, 1973, reversing expulsion of student who published in a student newspaper cartoon depicting sexual assault of the Statue of Liberty by a policeman with headline "Motherfucker Acquitted." Hass v. Indiana, 414 U.S. 105, 107, 1973, reversing conviction of individual who stated "We'll take the fucking street later" to a sheriff. Plummer v. City of Columbus, 414 U.S. 2, 4, 1973, holding that saying series of absolutely vulgar, suggestive and abhorrent, sexually oriented statements to a woman is protected speech. City of Cincinnati v. Carlin, 416 U.S. 924, 1974, vacating conviction and remanding for consideration in light of Lewis, where the defendant said to the police, "Get out of my way you fucking prick-ass cops." Lucas v. Arkansas, 416 U.S. 919, 1974, vacating conviction and remanding for consideration in light of Lewis, where the defendant said to the police, "Well, there goes a bid, sick, bad motherfucking cops. Look at the chicken shit motherfucker hide over there behind that sign. Now the sorry son of a bitch is going to come back over here." National Socialist Party v. Skokie, 432 U.S. 43, 1977, holding that the display of swastikas during a march through a community inhabited by Holocaust survivors is protected speech. Eaton v. City of Tulsa, 415 U.S. 697, 698, 1974, holding that saying chicken shit during cross-examination is protected speech. Johnson, 491 U.S. at 397, reversing conviction of individual for burning an American flag. RAV, 505 U.S. at 377, holding that burning a cross is protected speech. Snyder, 562 U.S. at 443, holding that signs that read, "Thank God for dead soldiers, America is doomed, priests rape boys, and you're going to hell" are protected speech. United States v. Alvarez, 567 U.S. 709, 2012, holding that lying about being a Medal of Honor recipient is protected speech. Madel v. Tam, 137 S. CT 1744, 1764, 2017, holding that racial slurs are protected speech. For example, in Lewis, a woman was found to have yelled "goddamn motherfucking police" at an officer. 415 U.S. at 130. She was convicted under a municipal ordinance that made it a crime for any person wantonly to curse or revile or to use obscene or opprobrious language toward or with reference to any member of the city police while in the actual performance of his duty. ID at 132, citation omitted. The court vacated the conviction and invalidated the ordinance as facially overbroad. In Hill, the Supreme Court put the final nail in Chaplinsky's proverbial coffin. The Hill majority reversed a conviction for criticizing police officers under an ordinance prohibiting such speech. 482 U.S. at 462-63. Justice Brennan stated, in what has become a famous line, that freedom of individuals verbally to oppose or challenge police action is one of the principal characteristics by which we distinguish a free nation from a police state. ID at 462-63. This differs not from the occurrence with appellant where a magistrate has accused appellant of disturbing the peace for verbally opposing police after being attacked without cause. Saying "go fuck yourself old man" is clearly protected, and the magistrate demonstrated an egregious failing in understanding constitutional law, supported by the district judge. Rudeness does not prohibit redress. Clearly the magistrate, and thus the district judge, prefer a police state where words against abusive public servants constitute criminal acts, and the people should never be rude to misbehaving public servants nor to confront corruption. This is shameful from the judicial branch, given the overwhelming amount of law making the very opposite unequivocally clear. In sum, Supreme Court jurisprudence has come to recognize that Chaplinsky's holding is an inherently dangerous concept in general, but, particularly, when applied to speech directed at public servants, as happened in this case, it is devastating to the concept of freedom of expression. Burton Kane, The Trouble with Fighting Words, Chaplinsky v. New Hampshire is a threat to First Amendment values and should be overruled. 88 MARQ. L. Rev. 441, 536, 2004. It is a blank check to the police to abridge speech and stifle criticism which has occurred in this matter. There is no Supreme Court case since Chaplinsky that affirms a conviction for criticizing the government no matter how vicious the language, or how untrue the charge. The Supreme Court has abrogated the Chaplinsky decision over 80 years. It is a dead letter. And that makes Chaplinsky no impediment to declaring TX Code Section 42.01 facially unconstitutional, and that the magistrate asserted such is demonstrative of a basic failure to understand constitutional law and speaks to the deprivation of rights under 28 U.S.C. 1915 where the unwealthy do not have equal access to the courts. That the adjunct attempted to create such a crime based upon appellant's criticism of police is unconscionable, and further to assert that appellant's speech was an acceptable cause of police brutality is simply inexcusable and identifiable with the magistrate's desired police state. Such is a clear bias and brings into question the competency of the inferior court officers. There is no reasonable articulation of a crime as the parking lot was bereft of civilians and the speech is protected speech. There is no arguable probable cause that appellant speech would create a public riot or public disorder, and the assertion that the police had full right to attack appellant for being rude goes against every law ever made regarding free speech in this republic. In his response to the report and recommendation, ROA.22-40653.501-539, appellant attempted to focus the inferior court's attention on the facts of the case, that it was appellant and not the police whose peace was disturbed upon being unlawfully seized, and that it was the out-of-control public servants who engaged in disorderly conduct in a shameful display of violence and threats of more violence against a non-violent photographer who was not and who had not committed a crime, and whose exercise of a well-established constitutional right should never have been the basis for being physically accosted and restrained. But given the inferior court officers' clear and present affinity for their beloved boys in blue, such was likely not on their minds as said magistrate made such wild assertions of crime for being rude as affirmed and adopted by the district judge.